A major legal battle over AI and copyright has reached a landmark decision. Federal judges have approved a $1.5 billion settlement between AI company Anthropic and authors who accuse it of illegally using nearly 500,000 books to train its chatbots. This case has sparked fierce debates about who owns the rights to AI-generated content and whether tech giants should be held accountable for their data practices. But here's where it gets controversial. Critics argue that AI companies like Anthropic are outsourcing their ethical responsibilities to the very authors and publishers they're accused of exploiting. While the settlement pays authors and publishers $3,000 per book covered, it excludes future works, leaving many questions unanswered. How do we balance innovation with fairness? And who decides what's fair when AI systems are trained on copyrighted material? U.S. District Judge William Alsup, who oversaw the case, called the settlement fair, but warned that distributing the funds will be a logistical nightmare. With 465,000 books allegedly pirated for training purposes, ensuring every author and publisher receives their share has become a complex puzzle. We have some of the best lawyers in America in this courtroom, and if anyone can do it, you can, Alsup said, hinting at the challenges ahead. The Authors Guild hailed the settlement as a victory for creators, arguing it sends a clear message: AI companies can't ignore the law. But Anthropic defended its actions, insisting the court's June ruling that AI training constitutes transformative fair use remains valid. This settlement resolves narrow claims about how certain materials were obtained, explained Aparna Sridhar, the company's deputy general counsel. We're focused on building safe AI systems, not on litigation. The controversy deepens when you consider that Anthropic isn't alone. Major AI developers have long used pirated content to train their models, raising questions about whether the industry is collectively guilty of wrongdoing. As Maria Palante of the Association of American Publishers noted, every other major AI developer has trained their models on the backs of authors and publishers. Yet, the settlement's details have also drawn scrutiny. Authors' attorneys argued that the claims process is designed to ensure transparency, with a September 22nd deadline for submitting forms to review the agreement. They claimed the deal was negotiated in the open, not through secret backroom deals that could favor well-known authors over lesser-known ones. Alsup's concerns were twofold. First, that the Authors Guild and the Association of American Publishers might pressure authors into accepting the settlement without fully understanding it. Second, that the process could inadvertently disadvantage smaller creators. Authors and publishers are sending a message to AI companies: you are not above the law, said best-selling novelist Andrea Bartz, who supported the settlement. Our intellectual property isn't yours for the taking. As the case moves forward, one question lingers. What does this mean for the future of AI and intellectual property? Will this settlement set a precedent that holds tech giants accountable, or will it simply be another chapter in the ongoing struggle between innovation and creativity? The answer may depend on how we define fair use in an era where machines learn from human creations. What's your take? Let us know in the comments.